Delighted to welcome you to this second of our two-part Wilderness Defense webinar series. And today is Wilderness Defense using the power of the law. And as wilderness lovers and wilderness advocates, it's truly an honor to be able to learn from four attorneys who've been on the forefront of defending the Wilderness Act and beloved wilderness areas. I'll introduce our guests in a moment, but first I want to let you know that today's webinar will be recorded and added to the Great Old Broads YouTube channel. And we will be sending out a link to everyone who has registered. So please feel free to send that link to any wilderness loving friends and fellow advocates. For those of you who were on our first webinar, we've been busy in Santa Fe the last couple of weeks training a crop of 20 new broadband leaders from across the country. So we haven't gotten that out yet, but that will be coming out very soon. I want to note that we are planning another webinar later this year to present views and experiences relating to wilderness from Indigenous perspectives. Today, we want to start by recognizing the problematic nature of public lands and wilderness as lands that were wrested from Indigenous peoples who belong to these lands since time immemorial. At Great Old Broads for Wilderness, we have committed to learning about the Indigenous peoples in the regions where our broadband chapters are working, supporting the critical importance of tribal sovereignty and self-determination, and working to achieve equity and representation at every table where decisions are made about the management of lands on this continent, all of which are native homelands. Our national office for Great Old Broads for Wilderness is based in Durango, Colorado. The Nooch peoples, whose name was anglicized from the Spanish pronunciation first to Utah, for which our neighboring state was named, then Ute, it lived and thrived in our area throughout our area. Today, 3 Ute nations recognized by the federal government are headquartered in Southwest Colorado and in Utah. Durango is also the ancestral homelands of contemporary Hopi and Pueblo peoples who worked and prospered here before moving in their long migration to their present-day homes. We acknowledge the lives and histories of these Indigenous peoples, along with those of the citizens of more than 200 tribal nations now living in Colorado. This land acknowledgement is a small step among many we are taking towards reconciling our histories. We're dedicating this webinar series to the memory of Clem Pope, who served as a devoted and self-described wilderness purist, and as a horsepacker, wilderness ranger, and wilderness manager for over 40 years on the Frank Church River of No Return Wilderness and the Selway Bitterroot Wilderness in Idaho. Great Old Broads is putting increasing focus on training our members about wilderness defense using litigation, arbitration, and mediation through a Wilderness Defense Fund endowment that was established by the Pope family at the end of 2021. We send our gratitude to the entire family and hope that these 2 webinars will help our members and supporters become proud wilderness purists and effective wilderness defenders. If you have questions about how you can get involved in this effort, please contact us at broads@greatoldbroads.org. Now, to get to the reason you joined us today. Since the passage of the Wilderness Act in 1964, wilderness designation has been the highest form of protection for public lands. Great Old Broads for Wilderness has been working to designate and defend wilderness since our formation over 30 years ago. We couldn't accomplish our work without the power of 2 key components. Each of you, as local citizens who know the wilderness areas that you love and serve as wilderness watchdogs and defenders, and all of the attorneys and legal defense organizations with whom we partner, who know the laws and policies related to wilderness and what to do when those laws are violated. There are few attorneys who have defended Big W wilderness with as much commitment and dedication as our guest speakers today. We feel immense gratitude to them for the work they do every single day and for sharing their knowledge and experience with us today. So I'll introduce each of them before they begin their presentations. We'll do all 4 presentations with a little time for question and answer after each one, and then more time at the end to talk more generally about the topics. So our first guest today is Laird Lucas. Laird has led environmental litigation for some 30 years and has won many decisions in federal and state courts in the West over public lands logging, grazing, water quality, endangered species, and more. Laird founded Advocates for the West in 2003 and serves as the executive director. Advocates for the West takes on some of the most controversial cases, and they have a track record of winning about 85% of the time. Those are pretty darn good odds, and it's one of the reasons our organization loves working with advocates. Laird graduated from Yale Law School in 1986 and worked for a high-powered San Francisco law firm until 1993, when he joined Land and Water Fund of the Rockies and then formed Advocates for the West later. All of us are lucky to have him as a litigator for the environment. So Laird, take it away.
Thank you so much, Shelley. And thank you to Great Old Broads and all of the great broads out there today. And I just got to say, I have enjoyed working with Great Old Broads for Wilderness for decades now. And my first introduction to Great Old Broads was through Ginger Harmon. We're going to talk about her in a moment. But I'm going to go ahead and share my screen and start my presentation, right? Okay. Uh-oh. Let's see if this is going to work. Lisa, you might have to do it.
Happy to.
Thank you.
Yes.
Sorry about this technical glitch. And while we're doing it, just to sort of reiterate what Shelley said, Advocates for the West is a public interest law firm. We represent conservation groups for free. We work with dozens of groups around the West, but we tend to have long-term partnerships with a bunch of different groups, and that includes Great Old Broads for the Wilderness. Thank you, Lisa. And today, I'm going to focus on the Frank Church Wilderness in Idaho, Frank Church River of No Return Wilderness. And Lisa, if you could go to the next slide. In particular, I want to talk about protecting the Frank Church and wolves in Idaho through a litigation we brought back in 2010, opposing winter helicopter landings. And if we could go to the next slide. The Frank Church Wilderness, of course, was designated in 1980 through the Central Idaho Wilderness Act. It incorporates the 1964 Wilderness Act, but it has some specific provisions. And the little map here I know is a little bit hard to see, but running through the middle of it is the middle fork of the Salmon River. There's important tributaries like Big Creek coming in from the west halfway through your screen. And of course, the Salmon River itself, the River of No Return itself, running through the northern part. But the Frank Church is the heart of the Idaho wilderness. And if we could go to the next screen. One of the important things about the Frank Church is it has provided a place for wolves to be reintroduced. And most of you probably know that wolves were reintroduced into Idaho as well as Wyoming and Montana in the mid-90s under an Endangered Species Act provision allowing the introduction of experimental non-essential populations. And the reintroduction of wolves has been a great success biologically. Wolves have thrived, except for where they've been killed and beaten back and trapped and hunted. And in wilderness, it's sort of the heart of the wolf population in Idaho. And wolves are known to be coming out of the Frank Church in order to come to other parts of the state. So protecting wolves in the Frank Church is a way of getting back to the true ecological values of wilderness. We need the apex predators. The ecosystem needs wolves there. And the Frank Church is a place to protect wolves, and protecting wolves helps protect wilderness values. If we can go to the next slide. In 2010, the Idaho Fish and Game Commission, or Idaho Fish and Game Department, which is directed by the Idaho Fish and Game Commission, which unfortunately is a politicized body that is anti-wolf. They wanted, of course, there's been lots of wolf killing in Idaho outside of wilderness, and tracking wolves and collaring them. And collared wolves tend to be become wolves that are dead wolves. If people know where wolves are, they can find them, they can kill them, they can track them, they can take out their packs. And yet the Idaho Fish and Game claimed they wanted to be able to study wolves. And they typically do annual big game elk surveys around the Frank Church in the winter. They do salmon surveys in the summer. They fly helicopters over, but they're usually a few hundred feet above ground. And this particular proposal would involve something different. While they're looking for elk, they would also be looking for wolves. In the winter, they find their tracks. They're trying to sight them. Once they find a wolf, they would fly very low above the ground and then stop, land in the wilderness, take their doors off the helicopter for dart guns, get back in the air, pursue the wolf, dart them from the air, then land, offload personnel and equipment, measure the sedated wolf, put a collar on it, take pictures with it, so forth and so on, and stay about a half an hour and then leave. And the Forest Service authorized a maximum of 20 landings, which sounds not very much, but if we could go to the next slide. The notion of helicopters in wilderness and landing in wilderness is really problematic. As we try to defend wilderness values, how do you protect against these kinds of motorized intrusions that are otherwise banned, and for things like putting on wolf collars? If we could go to the next slide. The big game surveys are kind of shown here with the Middle Fork running through both slides. Big elk populations located along the Middle Fork, as well as Big Creek and others. We knew this is where they would be looking for wolves, where strongholds of wolves are. And if we could go to the next slide. We brought a lawsuit. We actually built upon a prior case over wolf protection in the Sawtooth National Recreation Area. We expanded it and included Great Old Broads for Wilderness, as well as a number of other groups, many groups opposing this effort to increase helicopter use or use helicopters in wilderness to supposedly study wolves, but actually to provide for more ways to control and kill them. So if we could go to the next slide. Wilderness from 1964, and I know our other speakers will talk about this, and everybody understands this, but the definition of wilderness is the area on the earth that is untrammeled by man, protected and managed to preserve its natural conditions, and I've highlighted this, has outstanding opportunities for solitude or primitive, unconfined recreation. Because solitude and recreation are part of the wilderness definitions, that helps us in bringing legal claims in order to enforce wilderness. If we could go to the next slide. And specifically under the wilderness, federal agencies are responsible for preserving that wilderness character. And that includes the Forest Service here that manages the Frank Church. Next slide, please. And the Wilderness Act is explicit in many ways. No use of motorized vehicles, motorized equipment, no landing of aircraft or other mechanical transport in wilderness, except, unfortunately, as may be otherwise provided by law or as necessary to meet minimum requirements for administration of the area. This minimum requirements for administration is the loophole that typically is used by agencies to allow motorized intrusion, including helicopter or other aircraft landing. If we could go to the next slide. Now, the Frank Church was designated in 1980 with a bunch of landing strips that were already there, and those are sort of grandfathered in. So under the Central Idaho Wilderness Act and the Wilderness Act provisions we were just looking at, use of designated landing strips that was in regular use at the time of wilderness can continue, or again, as necessary to meet minimum requirements. So there are aircraft that go in and out of the wilderness, but they're supposed to be limited to the existing landing fields, not landing wherever the helicopters may find wolves or elk or whatever. If we could go to the next slide. So we wanted to stop this. We wanted to draw a line in the snow, if you will, to prevent Idaho Fish and Game and the Forest Service, which was collaborating with it and authorizing these landings, from allowing it to happen. We tried to stop it before it happened. Once it's happened, it's very difficult to do anything about it. We wanted to create precedent to help protect the wolves and the wilderness in central Idaho. So we brought an injunction motion, and in order to get an injunction, you got to show you're likely to win on your claims and that you will suffer irreparable harm. And this is where working with groups like Great Old Broads and our other clients that have people out on the ground, boots on the ground, people who get out in the wilderness, that's what we rely on in order to be able to win in court. We have to prove standing to bring the case, meaning we'll show injury, and we have to show irreparable harm to get an injunction. So we had to be able to prove to the court that our folks were going to be in the Frank Church in the winter when Idaho Fish and Game helicopters might be landing where wolves are, and that becomes a very difficult proposition to do. So if we could go to the next slide. For instance, the state of Idaho was arguing that we can't get an injunction because very few people go into the wilderness in the winter. But we provided declarations from more than 20 people stating they had concrete plans to visit these areas where the fish and game overflights would be and the wolves were likely to be, the Middle Fork salmon, Big Creek areas in February and March when the helicopter overflights were planned, and who explain their many prior wilderness experiences. We had to make it credible to the judge that our folks were actually going to be there when helicopters might come landing down to dart and collar wolves and destroy their wilderness experience. So if we could go to the next slide, please. We created a group of wilderness wolf watchers. These are members of Great Old Broads and other groups that in short order, in November, December of 2009, agreed to make plans to go out and look for wolves in the Middle Fork and Big Creek areas in the winter. And these are people who have a record of going out there. And many of them are Great Old Broads, even though they're active in many other organizations. And you may recognize some of the names. Edwina Allen, leader of the Sierra Club in Idaho for many, many years. Veronica Egan, Ginger Harmon, Marcia Lajos, Dana Menlove. Many of these people are longtime stalwarts and people who know the wilderness. We filed declarations from each of them detailing what their use of the wilderness has been, why they would be out there, and why they would be harmed. And if we could go to the next slide. We had to cover the Middle Fork and up and down because we weren't sure exactly where the landings would be, but we got people out there. A bunch of people flew in to the Middle Fork Lodge where there is a landing strip and a couple of other landing strips. And here's one of Mark Minlove landing on his way in. There was actually wolf tracks at the landing strip when they arrived. And if we could go to the next slide. We had folks from Winter Wildlands Alliance, Forrest McCarthy and others. They took in little pack rafts. They hiked into the snow, into the Middle Fork, got in their little boats and paddled the entire river that for a week or two in the middle of winter. There's actually a video on it on YouTube that's great. And if we could go to the next slide, please. And we had other declarations like this from Ginger Harmon. And, Ginger I've known for a long, long time. I've been so impressed by her. She has helped inspire me to do what I do to protect wild places from her personal firsthand experiences of so many parts of wilderness in the United States, from the Utah Canyon lands to Idaho to many other places. But here's her declaration filed in 2010. She's a founder of Great Old Broads, 20-year board member, 79 years old. She's planning to go into the wilderness in late February to snowshoe and enjoy the beauty of the wildlands. And if she heard or saw helicopters pursuing wolves, it would destroy the pleasure of her visit. If we could go to the next slide. I just want to acknowledge Ginger further. I realized as I was putting together this presentation that Great Old Broads has a Ginger Harmon Wildlife Advocacy Fund to help fund this kind of advocacy that we're doing to keep it going. And I just want to encourage everybody today, make a donation to the Ginger Harmon Wildlife Advocacy Fund and support Great Old Broads. So if we could go to the next slide, please. One of the things that happened was we did not actually win a preliminary injunction. The judge, Judge Windmill, a very fine judge, wrote an opinion that was carefully nuanced. Helicopters are antithetical to wilderness. It would be a rare case where machinery as intrusive as a helicopter could meet the minimum requirements for administration of the area. But then he said, this case may present that rare circumstance because the helicopters were to be used to collect data on wolves that were released to restore the area's wilderness characteristics. So Judge Windmill bought into the notion that this use of helicopters could be consistent with minimum requirements. And if we could go to the next slide. Even though he denied us a preliminary injunction, he said, hey, we share your concerns. Don't view this denial as a stamp of approval on helicopter use. He cautioned the Forest Service, Idaho Fish and Game, and others, use of helicopters for any other purpose would be extremely difficult to justify. And the next helicopter proposal will face a daunting review. The Forest Service must proceed very cautiously here because this law is not on their side if they intend to proceed with further helicopter projects. So while we technically lost the injunction, we felt like we achieved a lot by, again, drawing this line in the snow saying, all right, you might have been able to do it this one time, but in the future, you're going to have a really hard time justifying it. And if we could go to the next slide, please. I realized I omitted a slide here. So there should be a slide here right now talking about a second case that was brought in 2017, where Idaho Fish and Game came back. This time they wanted to collar elk, is what they said, to land and collar elk. Despite Judge Windmill's prior decision, the Forest Service gave very little notice. And another group, including Dana, who is on our call here today, brought subsequent litigation. And Judge Windmill at that time did grant, he did rule in favor of the plaintiffs. They were not able to seek an injunction because they didn't have advance notice, but they collared a bunch of elk and some wolves, even though it wasn't supposed to be for wolves. The plaintiffs went in and said, Judge, hold what they did unlawful under NEPA and the Wilderness Act, and don't let them use any of the data they gathered, and give us an injunction against future this kind of thing. And the judge granted it. So the judge said, hey, I told you a couple of years ago that you would face a very daunting review if you tried to do this again. You did it anyway. I hold that you violated the Wilderness Act and NEPA, and I'm not just slapping their hands. He really rapped them hard. There was subsequent proceedings, as this slide indicates, and they modified the injunction order. And then the Court of Appeals got involved, and it's an unpublished decision, but it affirmed in part and reversed in part. The reversal was mostly over the 90-day injunction, but really the Court of Appeals upheld the rulings that the Forest Service's approval of helicopter landings violated the Wilderness Act as well as NEPA by not giving the public adequate notice and opportunity to proceed. So if we could go to the next slide. This is an example of using litigation over the long term to try to protect wilderness. I think we've helped establish good precedent. I don't think the battles over protecting the Frank Church are done. The battles over protecting wolves certainly are not done. But this is an example of how working with groups, with people who get out on the land, who care about wilderness, who are willing to stand up and talk about it, can make a difference. So that's my presentation, Shelley, and thank you, Lisa.
Thank you so much, Laird. That was wonderful. And thank you for the details about how we as citizens can make a difference, and how being involved in groups like Great Old Broads is what really will help legal cases. I want to just see if there are any questions for Laird specifically about this presentation. And if there are, feel free to unmute yourself and or put your question in the chat. And if not, we will move on to our next presenter, and we'll still have some time at the end to go back and go over questions. Thank you very much. Okay, great. Our second guest today is Dana Johnson. Dana is staff attorney for Wilderness Watch, a national wilderness conservation organization based in Missoula, which I'm sure many of you are quite familiar with. Dana has been with Wilderness Watch since 2014. She coordinates Wilderness Watch's overall litigation strategy, representation in federal court, and cooperation with other attorneys and legal interns. I had the opportunity to work with Dana on litigation against chainsaw use in 2 Colorado wilderness areas, and we've also appreciated her work defending wilderness and environmental concerns throughout the Northern Rockies. Dana will speak about on-the-ground monitoring in wilderness and how data collection can be valuable in looking at prohibited uses, and she'll have some case studies from the Selway, Bitterroot, and the Boundary Waters, and perhaps other places. So Dana, thank you for being with us today.
Yeah, thank you, Shelley. The slides up here, and thank you, Lisa, for handling my slides for me. Can everybody hear me okay? Great. As Shelley mentioned, I am staff attorney for Wilderness Watch. I've been there since 2014, and I've had the pleasure of working with a lot of people on this call, the other attorneys, and a lot of the individuals involved in Great Old Broads. And with my presentation today, I'm going to focus on just a couple of examples where folks on the ground can really help both before and during litigation. And hopefully the discussion will spark some ideas on how folks can get involved. And I'm always happy to chat with people too, as various issues come up. So if we can go to the next slide. One of the most common scenarios in wilderness litigation is challenging agency decisions authorizing one of these listed prohibited uses from the statute. And Laird touched on this already with his presentation, but we're talking about things like motor vehicles, aircraft, structures, installations. And often when we're challenging these things, we're trying to show that these uses are not necessary for administering the wilderness. And so I'm going to highlight one helicopter project where information gathering from folks on the ground could have really helped us in challenging the project. We can go to the next slide. So this is an old catwalk. It's at the Fred Burr High Lake Dam in the Selway Bitterroot on the Montana side. It's obviously a pretty simple structure. It's made out of, old logs, native materials. And the dam itself in this location was built and maintained for nearly a century without the use of motorized access or tools. We can go to the next slide. And as you can see here, it's about a 10 or 11 mile trail that goes up to this dam. It's kind of right through the middle of your screen there. About half of it is inside wilderness. About half of it is outside of wilderness. And historically, the dam operators for the Fred Burr Dam would ride horses or they would walk up this trail to check on the dam and to do regular maintenance work. But back in about 2010, the old catwalk made out of those logs started falling apart, was deteriorating. And so they needed to replace that catwalk. And of course, as is the way of things nowadays, the dam operators wanted to replace that old catwalk with a 16-foot long prefabricated metal ramp. And of course, because hauling a 16-foot long hunk of metal up this trail to the dam is fairly complicated, they wanted to use helicopters to take this in. And so the Forest Service, when they were considering this project, they looked at a non-motorized option that would have allowed them to cut this metal ramp down into smaller sections, haul it up this trail and assemble it on site. The dam operators, when they heard of this alternative, argued against it, noting, among other things, that this last 1.5 miles of trail was too unsafe to pack materials up. And so if you see on this screen, kind of down in the lower left-hand corner, just before you get to Fred Burr Lake, it gets pretty switchbacky on that last stretch going up the trail. And so besides arguments about designs of the catwalk and whether a metal structure was even permissible, given that they had a very basic catwalk made out of native materials that worked just fine for decades, one of the central issues in this case became concerns about access on this trail and the feasibility of packing materials up the trail. So Wilderness Watch requested a field visit from the Forest Service before they made their decision, basically to go in and ground truth the trail conditions in this area. We had a strong hunch that the trail was not in as bad of shape as they were making it out to be, and that packing materials into this area was feasible. Wilderness Watch also offered to have its members haul in the supplies on foot and get volunteers out there and lug up the materials for the dam operators and for the Forest Service. Probably not surprisingly, the Forest Service refused both of our requests, and they authorized the dam operators' plans. And so we sued, but unfortunately they got in there with the helicopter and with the metal ramp before we could stop them. But we learned a few important things from this case that I want to share with everybody today, because it's been helpful in challenging projects like this since then. So later that year, after we challenged this project, one of our members, and I believe his partner, who were, I also believe, well into their 70s, hiked up this trail to the dam without any issues, took a bunch of great pictures of the trail. Unsurprisingly, the trail was fine. It would have been feasible to pack materials into there. And so it would have really been nice to have those pictures available to us, both when we were talking to the Forest Service in advance of litigation and once we got to litigation, to show the court that there were alternatives to helicopter access.
Idiot, why didn't you do it?
Zoom. And another thing that would have been really nice to have in this particular circumstance is folks carrying, we thought about having people carrying different loads up the trail with different dimensions and different weights and document this so we could show that this could be done. It would have been nice to have retired agency folks involved, especially people who might have certifications in things like crosscut saws, or who are involved in other dam projects where they completed the project without helicopter use and without motorized tools and using native materials that were found on site. And so gathering facts on the ground and engaging with the agency folks who have done things the right way in previous projects is really important. And I think it's a place where we could work both with our own membership and with Great Old Broads members going forward to get more of this into the record going forward. It would be very helpful. If we can move to the next slide here. And another area where folks on the ground can really help out a lot is when we're challenging commercial services in wilderness. And so commercial enterprise is prohibited in the Wilderness Act, but there is a special provision for commercial services, which generally refers to services that are offered by outfitters and guides. These services, however, can only be offered to the extent necessary. It's kind of the operative phrase that we're dealing with. For realizing recreational or other wilderness purposes of the area. So oftentimes we're talking about recreation access when we're dealing with this. If we can go to the next slide. And to illustrate this, we have a commercial services issue that's ongoing in the Boundary Waters Canoe Area Wilderness, where folks on the ground, or I guess in this case, folks on the water, could be really helpful. And for those who aren't familiar, the Boundary Waters is this just spectacular network of waterways and land portages that connect lakes that run along the United States and Canada border. And this aerial view is pretty zoomed out, but at least gives you a sense of the landscape that we're looking at here. So this area is wilderness, so most people travel via canoe, and they put in at various designated entry points. You have to have a permit to put in at one of these entry points, and then you can stay overnight at designated camp spots that are kind of dispersed throughout the wilderness. And these camp spots are first come, first serve. Unfortunately, in the Boundary Waters, there's legislation that allowed for motorboat use on some of these waterways. And commercial towboat operators run a pretty big business hauling people and their canoes from these drop-off points into areas that are deeper into the wilderness so they can get in farther more quickly. And as you can imagine, people paddling in canoes are at quite a disadvantage for campsites when they're competing with motorboats. And it's obviously not much of a wilderness experience when you have boats buzzing back and forth around your canoe. And it's kind of funny at this, the area that has the yellow push pin on it there is one of the big entry points into the Boundary Waters. And myself and a couple of other folks from Wilderness Watch were out kind of checking out the area, and we ran into an outfitter who was loading some of his towboats into the water there. And I don't think he knew who he was talking to. And he started chatting us up and talking about how their business is going up because lots of people who would never consider taking a motorized towboat into the wilderness are hiring him for tows just because it's so miserable trying to paddle through these sort of bottlenecks of motorized use in the Boundary Waters wilderness. And so it's really a self-perpetuating problem in this area. And so we challenged the proliferation of commercial towboats in court a few years back. And as part of a settlement agreement that we got in that case, the Forest Service is preparing what's called a commercial needs assessment to determine first, whether these commercial services are necessary at all in the boundary waters, and if they are necessary, the extent to which they're necessary. And so one of the farthest drop-off points for a tow in this area is about probably a half day's paddle. And as I mentioned, the red or the yellow push pin there indicates one of the big entry points for the boundary waters. It's called the Moose Lake entry point or Moose Chain. And so towboat operators pick folks up with their canoes, strap them onto the towboat, they put into the water here, and they follow this lake chain up to where the red push pin is. And that's a place called Prairie Portage, and it sits right on the US-Canada border. And one of the things that we would like to show as we're going through this commercial needs assessment process is that it is feasible and relatively easy for most people to get from that first push pin to the second push pin. And there are lots of other places where towboats take people in the boundary waters, but this is the farthest stretch. And so we'd like to get our members and potentially members of Great Old Broads and other groups out on the water to demonstrate that people, in various age demographics, varying physical abilities, can get to these areas without commercial towboat services. So hopefully the goal is to reduce or eliminate a lot of these commercial uses in the boundary waters. It would also be great when we're doing this to get some video and audio showing the frequency of these boats buzzing back and forth, and also just how loud and disruptive they are. When we were standing there at the Moose Lake entry point, it's really astounding just how much noise is generated by these boats. And they're going back and forth really frequently. So photos and videos from our members really help to make the problems we're talking about and a lot of litigation and a lot of these discussions with the agency less abstract. If we can go to the next slide, please. And lastly, I just want to briefly touch on another area where involvement from our members is increasingly important. And that's where an agency is authorizing an action that might not include a lot of the expressly prohibited uses like motorized use and helicopters and things like that. But the action fundamentally undermines the preservation of wilderness anyway. And so this includes things like intentional manipulations of natural processes, wildlife populations, and vegetative communities. And we're seeing more and more of this coming in, with the agencies using climate change as the justification for intentionally manipulating wilderness. And as you can see on this slide, one agency, it was the Park Service in this case, stated that its policy prior to climate change was to take a hands-off approach where overt human influences were not the primary reasons for population fluctuations in wilderness. And it now believes, as a result of climate change, that its role is shifting more to adaptive management to maintain quote unquote natural conditions. And this is something that we're hearing more and more across the agencies. And so as an example, last year in Montana, we litigated and stopped a massive fish poisoning and stocking project in the Scapegoat Wilderness, where the project justification was to establish kind of a cold water refuge for cutthroat trout in high elevation streams and lakes, even though the area where they were going to be planting the cutthroat trout was historically fishless and it was in the wilderness. That project also involved a lot of motorized use and dumping rotenone in about 70 miles of the North Fork of the Blackfoot River and a bunch of lakes up in the wilderness. We're also commenting right now on a couple of vegetation manipulation projects that involve planting white bark pine and sequoias over multiple years, and that's happening both in Montana and California. And both of those, the agencies are stating, are in response to vegetative change and stressors caused by climate. And so this is an area where the law is not well developed yet, at least outside of the motorized use issues. And so it really helps to have folks engaging with the agencies early on and kind of shaping the narrative and advocating for wilderness, and also advocating for protecting these wildernesses as an endangered landscape. And so we're interested in working with folks more on those issues going forward. We can go to the last slide here. And see how we can coordinate our efforts. And I think webinars like this are really important to keep the conversations rolling. So thanks for having me, and I will hand it back.
Thank you so much, Dana. I think what I'll ask is if you can raise your hand, that might be the easiest way for us to see if there's a question. Under reactions on the right side on the bottom of your screen, there is a button on the bottom that says raise hand. So if you have a question, and feel free to do this during the presentation because we can just save those questions till the end, just hit that raise hand button and then we can call on you. So if there are any questions specifically for Dana at this time, either raise your hand. Okay, we have 2 participants who've raised their hands. Let's see, I just have to find them.
We have Ann Delvera and then
you.
Clinton Nagel.
Okay, Ann.
I was just wondering if I can contact some people who might be able to help with the Boundary Waters effort. Who should they contact?
That would be fantastic. They can get in touch with me. My email address was there on that last slide, but I'm happy to share it as well. I'm pretty easy to find if you look at our website.
Okay, thank you. I will.
Great, thank you.
Okay, Clinton Nagel.
Yeah, well, I live here in Bozeman, Montana, and we have a Custer Gallatin National Forest just south of us who has done a 2020 revised forest plan. The record of decision just got released in late January. And there are obviously a lot of things there we don't like. And we would like to take litigative action here, but we keep on hearing from a lot of lawyers and such that a lot of the decisions made by the Forest Service that they have pretty much it's kind of a matter subject of opinion that when you go to court, it's a lot of times the courts will side with the Forest Service because of their experience, and so it's up to I guess the plaintiffs to prove otherwise. But it seems like that there's a built-in difference or deference to the Forest Service in a lot of these cases. Any ideas how we can get around that?
Well, speaking specifically to wilderness issues, it's a little bit easier because there are built-in prohibitions within the statute. And I'm not familiar with that particular forest plan and the issues that are going on there. I've heard some general stuff about it, but I'm not sure if there are wilderness specific issues that you're concerned about. Or
the forest has a WSA that right now it's 155,000 acres, and they want to reduce it, basically that part of the WSA down about half, and then they want to open that portion up to forms of recreation and that type of thing. And obviously that's got to be determined by Congress, I believe, right? I mean, there is some disagreement over that even. So any insight you could give us would be extremely helpful.
Yeah, I know that some of the other folks on this panel have probably done more National Forest Management Act litigation that I have, and it's probably wading into some of that territory. So I will defer to others if they have any words of wisdom on that.
Yeah. Some people say that you really can't sue the Forest Service until there's actually a project that violates the plan, I guess, or NEPA. So
Let's save that question until the very end and see if we have other panelists who might answer that rather than getting into the specifics of it right now. It's a great question and an important one that I know Great Old Broads has been very involved with as well. So we'll
Yeah.
save that to the end. Thank you,
Yeah,
Dana, and we'll move on now to our third speaker, Pete Frost. Pete is an attorney with Western Environmental Law Center, where he has worked since 1999. He litigates in both federal and state courts to defend forests, wildlife, and wilderness throughout the West. Pete's work has earned him a David Brower Lifetime Achievement Award. He's on such cases as protecting states' and tribes' voices on clean water across the country, controlling bear baiting in grizzly habitat, protecting native steelhead trout in Oregon's Santiam River, protecting amphibians in the Sierra Nevada, and much more. Pete has deep roots in Idaho and Oregon and graduated from Stanford University and the Oregon School of Law. Pete will be speaking today on the legalities of installments and structures in wilderness. So thank you, Pete, for being with us.
Hey, Shelley, thank you. Can you put up the first slide, please? Can you focus? There you go. So I too would like to begin by thanking Great Old Broads for having me. I have to confess, I've always been a little bit intimidated by the name because I'm the son, the grandson, and the great-grandson of Great Old Broads, some German-American women that came to the American West early in the century, and they are not to be trifled with. But before I begin, I'd also like to acknowledge in particular George Nickus and the staff and members of Wilderness Watch. It is an organization that I have had the honor to represent a number of times in court, including on the issues I'm about to talk to you all about this morning. So I'm going to be talking about structures and installations. And I'd like to begin with the caveat that both Laird and Dana mentioned, and that is, although there are general prohibitions in the Wilderness Act as to certain things like structures and installations, there are also caveats, and the primary caveat is the one that Dana focused on, related to things that are accepted as necessary for the administration of the area. And that has always been a hurdle in the lawsuits that I've undertaken related to specific structures or installations. Some of them have been successful and some of them have not. So I'd like to tell you all a few stories about how these provisions have worked out good and bad. Next slide, please. This is the Immigrant Wilderness in the Sierra Nevada on the west slopes. It's just north of Yellowstone National Park. Beautiful granitic country full of alpine lakes, including some lakes that are not lakes. Next slide, please. This is Buck Lake. It is formed by an impoundment in the wilderness. Next slide, please. You see, back in the 1930s, some folks thought it would be good to build what are called check dams on creeks in the Immigrant, because these streams would dry up after snow melt, and all you'd have were beautiful, gorgeous alpine meadows. So we needed some fake lakes. And one of the good things about fake lakes, next slide, please. Now, this isn't the Berlin airdrop. This is how you put thousands of trout fingerlings into fake lakes in the wilderness. But next slide, please. When the fake lakes dry up in the summer, this is what you're left with, rather than the natural meadows and riparian areas that you would have in wilderness, where they're not impounded creeks and streams. You end up with a lake that looks like this. So in the 2000s, we sued in federal court in the Eastern District of California. We sued the Forest Service for authorizing the repair and renovation of a number of check dams in the wilderness. And we were successful in proving that they were structures and installations that were not necessary for the administration of the area, and in fact, harmed the wilderness values. My second story, next slide, please, concerns a fire lookout in the Glacier Peak Wilderness in Washington. Glacier Peak is on the west side of the Cascades, very beautiful place, heavily visited, given its proximity to the Seattle and Tacoma metropolitan areas. It also gets a lot of snow. Next slide, please. And provides habitat for wonderful critters that are snow dependent. Next slide, please. One of the installations that was in the wilderness when it was created, or designated, excuse me, was an old fire lookout. And one winter during a very heavy snowpack, the snow collapsed this fire lookout. And the Forest Service's response was to illegally fly in helicopters and remove the lookout from the peak. So there was no lookout left there after it had collapsed. And then secretly, and I mean that respectfully, but I mean that honestly, without doing anything under the National Environmental Policy Act or issuing any public notice or comment. Next slide. Forest Service came back and decided to rebuild a lookout to make it look as much as possible like a sauna in Park City. And it actually said in court that this was the old lookout because it had salvaged some of the shutters on the windows, doorknobs, and hinges, and therefore represented to the court that this was the old lookout with some few restorations. We sued over those decisions, both under the Wilderness Act and evading public comment and notice as to those decisions. We were successful before a federal judge in Seattle, but unfortunately, after that judge ordered this recitation of the lookout to be removed from the wilderness, Congress passed a rider and exempted it from the Wilderness Act, so it remains in the wilderness today. My third story, next slide, please. This is about the Kofa Wilderness. As all of you probably know, often you will have a federally designated area such as a national park or a national wildlife refuge, and within it, there will be designated wilderness. And that is the case for the Kofa in Western Arizona. It's super dry country. It's in the middle of a wildlife refuge, but it is designated wilderness. Next slide. The refuge was created in the 30s primarily in order to create a sanctuary for desert bighorn sheep. And as you probably know from the laws that control how refuges are run, the sheep were primarily being propagated there for hunting. And hunting is allowed in the wilderness area. Over the course of a number of years, with the growth in the desert bighorn sheep population, the mountain lion population rebounded as well. And there began to be a cyclical swing in the number of bighorn sheep that were in the Kofa. And that left the Fish and Wildlife Service concerned because of the demand for hunting opportunities within the wilderness and within the refuge more generally. And so its response was, next slide, let's build water guzzlers where we trap any rainfall in the desert. We trap them in underground pipes, and then we have structures that are above ground that will trap water so that desert bighorn sheep can survive. And I got this case from another attorney in Arizona, took it up on appeal, and unfortunately lost before the Ninth Circuit because, as the court held, it found that because the desert bighorn sheep were a wildlife feature of the wilderness, then building structures in order to enhance and propagate that wildlife feature was not impermissible under the Wilderness Act. Next slide. My fourth story is about Yosemite. This is in Yosemite National Park in particular, and I don't know how many of you are familiar with it, but 94% of Yosemite National Park is actually designated wilderness, 704,000 acres of it. And that includes Half Dome, which is pictured here. It enjoys or suffers, depending on your perspective, enormous visitation. And in order to facilitate that in a safe way, the Park Service decided it needed to erect some structures along Half Dome to provide for safe visitation. Next slide. And so what you have there now, you have a cable system and post system to get up there safely because of the number of search and refuge situations they had on the park. We have never challenged that. This may be the kind of sort of thing that you may find to not be too untenable in wilderness, but it is one, I think, that is a part of what Dana was mentioning a bit ago about facilitating recreation. And when you have these kinds of numbers, it may be that this kind of structure is something that you accept. And finally, I'd like to turn to the next slide. This is the Silver Peak Wilderness just south of Big Sur on the California coastline. It's absolutely beautiful country. Unfortunately, in the Silver Peak, next slide, there is a fair amount of livestock grazing. And I'm not going to talk about livestock grazing per se as an activity. Our next speaker is, but as those of you that have hiked, backpacked in the American West in wilderness areas have experienced, it is full of our friends, the barbed wire and water troughs. And that is not because of any sort of necessary for the administration of the area caveat that would otherwise apply to prohibited installations and structures. That is because of grazing guidelines that Talasi will address next. Shelley, that's my quick 5-story recitation.
Excellent. Thank you so much, Pete, and for those specific examples. I don't see any questions in the chat. If you have a question directly related to Pete's presentation, please use the raise hand feature under reactions. Let's see if there are any questions. Looks like we have one. So yes, go ahead with your question. And that is Ann Dalvera. Oh, I believe. Yeah. Ann, if you'd like to proceed.
Hi, yes, I did put a question is whether the enabling legislation for the Kofa Wilderness included any statements saying that it was for the purpose of providing a refuge for the desert bighorn.
That is a perceptive question, and the answer is no. And the court did find that the Wilderness Act superseded the Wildlife Refuge Act as to how the wilderness within the refuge would be managed. So that was a good aspect of the case. But the ultimate outcome, which I alluded to, was really bad because it's sort of a camel's nose under the tent holding, where because the court found that wildlife, which is a feature of wilderness, can be enhanced, a number of agencies are moving toward the features provision of the act, which talks about historic things and wildlife and cultural things. They're moving to that provision of the act in order to either resurrect or create things that otherwise would be prohibited under the more general theory that Dana mentioned. And so I'm very supportive of Wilderness Watch's pressing the issue in that respect as sort of the integral meaning of wilderness, because I think that's a way to stop this kind of bad stuff from happening.
Yes, and it does have to do with the issue of trammeling as well.
Yeah.
Thank you.
Thank you, Anne. We have another question from Karen Lee, if you'd like to unmute, Karen.
Right. Thank you. In regard to the Kofa Wilderness and the water guzzlers, I remember in the previous webinar, it seemed that there was an additional case where there were existing 40 water guzzlers, and then they wanted to add 2 more. And there was a study performed as part of that case where based on data using motion sensing cameras, that the additional 2 water guzzlers were benefiting like coyotes and mountain lions, and actually not the bighorn sheep. So I think at least my vague recollection of the previous webinar, it said, I think the addition of the 2 more water guzzlers was struck down. Do you recall anything about that? Maybe a separate case.
No, forgive me, Karen, I don't. But I do remember 2 things. You're right about one thing. Well, number one, wildlife populations are cyclical. So the fact that the desert bighorn sheep was dropping off due to a growth in cougars, well, that's what happens in wilderness. And we stress that. That didn't work. We also did indicate in the case that the guzzlers were being used by cougars, not just by bighorn, and that didn't work. The judge that wrote the opinion had also determined that a fish hatchery in Alaska that was propagating hatchery fish in order to have the commercial fleet in the bay get more money was not a commercial enterprise. So we were kind of running up against someone that had a different idea about wilderness than I think the case law would support. So it really is kind of a bad facts can make bad law kind of situation on the Kofa, and it was an unfortunate result because I think it was a principled undertaking to undertake, but it just turned out the wrong way.
Thank you.
Yeah, thank you.
I'll add in, George Nickus has put a comment in the chat that says, Pete, you sold yourself short. We did win the Kofa case, but the way the decision was written and the relief granted created problems for wilderness.
Well, thank you, George. I didn't pay him to say that. Not that I'm above that.
And I will just point out too for Karen that was actually the Kofa water tanks that you're referring to. And there were several, I believe, outside of the wilderness area. And then there were a couple that they were going to put in right inside the wilderness area.
Very good. Well, we can continue to talk a little bit more about this after the next presentation. So I'd like to move on to our 4th and final presentation. And Talasi Brooks is going to present to us. She is the staff attorney for Western Watershed Project. And she's known both to Advocates for the West, where she worked for 4 years as a staff attorney, and to Wilderness Watch, where she completed an internship. Talasi has a JD from the University of Montana School of Law and an MS in Environmental Studies. Her legal work has focused largely on protecting sage grouse and on reining in the predator-killing wildlife services. Talasi will wrap up our session today speaking on an allowable use in wilderness livestock grazing, but one where citizen action can play a very important role. So Talasi, we're looking forward to your presentation.
Thank you so much. Let me just see if I can share my slides here. Haha, looks like it's going to work. All right. So can everyone see those okay? All right. So as everyone else has already talked about, I mean, it's often been said that what distinguishes wilderness from non-wilderness is what's not allowed in wilderness. And so we've talked a lot about some of these things: no commercial enterprise, no roads, and those types of things. And there are certain prohibited uses, as we pointed out, that are also not allowed except as necessary to meet minimum requirements for the administration of the area. And as Anne, I believe, posted in the chat, it's really important to recognize that minimum the administration has to be for the purpose of the chapter. So that is to say, minimum requirements for the administration of the area as wilderness. And I think that a pretty major problem with how the agencies commonly interpret that is, instead of recognizing that they can only authorize these forbidden uses to administer the area as wilderness, they instead look at it and say, well, what are the minimum requirements to administer this particular use that we want to authorize in wilderness? So oftentimes when we see agencies looking at these questions about whether they can authorize motorized or mechanized use or other types of structures or installations, they're asking the wrong question at the outset. And that's an important thing for you all to keep in mind when you're commenting on these proposals and when you're weighing in with the agencies. And it was pointed out to me by Chris Barnes, I'll add, who I see on the is listening here. So this is just a basic map of wilderness areas sort of focused on the west. This is from wilderness.net, which has a much bigger map that I tried to include, but I couldn't get it to include as a slide. Wilderness.net generally has a lot of great resources on wilderness, including, important articles that have been written on wilderness, all sorts of stuff that you can look through there, including this excellent map. Anyway, getting back to minimum requirements. So to aid the agency managers in making decisions about when an activity is really necessary to meet minimum requirements for administration of the area, the agencies came up with this minimum requirements decision guide. And in general, this was well intended. It was intended as a tool to help agencies, but in practice, it's often misused, and it is used to rationalize decisions, essentially, that are bad for wilderness. And I'm going to give an example of that coming right up here. So looking at grazing in wilderness specifically, the Wilderness Act has a special provision that says essentially that grazing where established prior to wilderness designation can be permitted to continue. And it is permitted on about 13 of the 52 million acres of federally designated wilderness, which is roughly 25%. And that number comes from a fantastic white paper that Wilderness Watch put together a few years ago. It's available on Wilderness Watch's website. If you ever are trying to deal with a wilderness grazing question, I would definitely suggest taking a look at that. It's a very, very good resource. So here are basic problems that occur because of wilderness grazing. There are conflicts between livestock and wildlife. And examples are, predation, predator control. Wildlife services may want to come in and kill predators, or also disease transmission. Domestic sheep grazing poses a really big risk to bighorn sheep, which are susceptible to diseases transmitted from domestic sheep. There's also ecological damage, as well as management issues such as motorized uses, structures, and installations. Pete showed an example of fencing in the wilderness, and you'll see that in a second. And then also the improper use of the MRDG to authorize, motorized use and other kinds of structures and installations. And there's probably some others that many of you can think of. And so here are just a couple of examples. These are pictures taken by Western Watersheds California Director, Laura Cunningham. On the left, you see a watering tank in wilderness, and then you see this trough, and you can see how the vegetation in that area is all beaten down from cattle concentration. And here are a couple other examples. On the left, you see new barbed wire fencing being put in to fence off grazing pastures. And then on the right, this is an area where there were going to be new cattle watering facilities to be built to help with cattle grazing during drought. So these are the types of things that get authorized to promote grazing in wilderness that are obviously bad for wilderness character. And in addition to the blanket sort of authorization for grazing to continue in wilderness, in most post-1980 pieces of wilderness establishing legislation include what we call the Congressional Grazing Guidelines. And those are in Appendix A of House Report 101-405, which you'll see referenced in the establishing legislation typically. And those have a few important provisions. They say that the number of livestock is expected to remain at the same approximate levels. They say that where practical alternatives do not exist, maintenance or other activities may be accomplished through the occasional use of motorized equipment based on a rule of practical necessity and reasonableness. And so, for example, motorized equipment need not be allowed for placements of small quantities of salt or other activities where such activities reasonably and practically can be accomplished on horseback or foot. And then they say they have a provision for use of motorized equipment in emergencies. And then finally, they say the general rule of thumb on grazing management in wilderness should be that activities or facilities established prior to the area's designation as wilderness should be allowed to remain in place. But as you can see, this places some limits on what can be authorized by the agency. Again, this is something that it seems to me that agencies tend to forget when they're authorizing grazing in wilderness. So this is our example. And this was Battleship, Upper Bench and Lower Bench allotments in Colorado. So BLM issued a decision to renew a 10-year grazing permit to graze these 3 allotments. And part of the allotments fell within the Black Ridge Canyons Wilderness. And the Black Ridge Canyons Wilderness establishing legislation incorporated the congressional grazing guidelines. So this is essentially the decision allowed motorized access to wilderness. And they had several examples of this, but the largest problem was that the decision allowed the permittee to use motorized equipment to check on livestock to avoid or detect emergencies while livestock were grazing in the wilderness, or to haul camping supplies to support the annual gather. And so authorizing essentially unlimited use to check on livestock to tell whether an emergency exists is a lot different than using motorized use in true emergencies to rescue sick livestock. Essentially just authorized unlimited motorized use. So what is wrong with this? Well, first of all, BLM didn't check to see whether the amount of grazing authorized was consistent with past use. It unlawfully allowed motorized access to check on livestock to avoid or detect emergencies, haul camp supplies, and place salt without asking whether those activities could reasonably be accomplished by other means. And then it relied on a flawed MRDG because the minimum requirements decision guide determined this was the minimum required to support grazing, rather than looking at whether it was necessary for a wilderness purpose. So what did we do? Well, this was a BLM grazing decision. So we filed an appeal, a notice of appeal and petition for stay. The stay was denied. And so we dismissed our appeal. And now we have the option of going to federal court, but we haven't done it yet due to other priorities. And so I wanted to give some of you, since you are wilderness activists, a really quick overview of how to appeal BLM grazing decisions. First, you need to ask in writing to become an interested public for the grazing allotments you're interested in. And then they'll have to send you proposed grazing decisions, and you'll have an opportunity to protest the decision, a proposed decision, within 15 days of receiving it. And then once the protests are resolved, BLM will send you the final grazing decision. And then if you want, you can appeal or seek a stay of the decision. And the appeals process has some advantages and disadvantages. The advantages are it offers an opportunity to get another level of review of the decision, essentially. So sometimes BLM will decide to revisit the decision and try to fix it unilaterally. It can offer opportunities for settlement with BLM, which can be good. And you don't have to be a lawyer to take advantage of the appeals process. So as a citizen, it gives you a chance to like get in there and have a say. And disadvantages: complicated and burdensome, lots of deadlines, and generally poor outcomes. So unless BLM decides to not do the same thing, the chances of getting the hearings division to tell BLM to do something different are pretty slim. And Laird has much greater experience with that than I do. But in general, I would say, there are some pretty significant disadvantages. And so with that, does anyone have any questions?
If you have a question, please raise your hand and we'll look for those, or use the chat feature. I'm not seeing any. Oh, there's one question. Let's see. It's from Susan Osley. So Susan, if you would like to unmute.
Yeah. One of the things I'm running into is that there's a lot of pressure to change what kind of mechanized equipment can be used in wilderness, like the Sandia Mountain Wilderness, in order to mitigate the risk of catastrophic wildfires. And this may be outside the purview of this whole thing, but there's a lot of pressure in the forest plan in New Mexico through adaptive management to, stick the camel's nose under that tent and start using chainsaws and all kinds of stuff in wilderness because of the danger of catastrophic wildfire, which is going on right now in New Mexico, as you may have heard. Thanks.
Well, so one thing is, like, it's interesting that they're saying that they want to reduce the danger of catastrophic wildfire by using chainsaws, which carry danger of sparks that could ignite a catastrophic wildfire, instead of crosscuts that don't have that. And there are others on this call who may have more experience with dealing specifically with, the kind of ecological threat side of things. But, I think that at the very outset, there's sort of like a logical issue with that justification.
There
Part
is
of
a
it is they
provision.
want to get it done fast. That's the pressure. We need to do it fast.
Yeah, I think we'll be seeing more and more of that as well with the ecological interventions. And there is a provision, a special provision in the Wilderness Act that says actions can be taken in response to fire, insects, and disease. And it's a pretty short provision. To my knowledge, I don't think there is any, and if there is, there's very little litigation out there on that issue. But from my research and from others' research, that provision was meant to address sort of exigent circumstances when there is, an active fire or an emergency taking place, and not these sort of proactive preventative measures like you're talking about. So the prohibition on motorized access and use should still apply in those circumstances.
So also a couple of years ago, we talked a little bit about examples of times when, like examples of where the agencies did the right thing, or Dana did. And so a couple of years ago, there was a situation, and I'm going to get some of the specifics wrong, but I think there was an enormous amount of deadfall. And I believe it was the Cumberland Gap or somewhere, maybe you remember, Dana, but they tried to clear it, and they had one crew working with chainsaws and one crew working with crosscuts, and the crosscuts came pretty close to the chainsaws. So that's a good example that shows that really chainsaws are not necessarily that much faster.
We have a comment here from Chris Barnes that says, I think part of the problem with Sandia is that in places the wilderness boundary is the forest boundary and private lands immediately abut the wilderness. So just to add to Susan's question there. We have another question that I think relates closely to what we're talking about. And this question is for both Dana and Laird. It says, such complex issues re natural conditions with climate change. As you all know, Coloradans voted to reintroduce wolves. Last webinar, there was a discussion about reintroduction of wolves in wilderness as perhaps contrary to the Wilderness Act. Can you speak to this issue at the end of the webinar? So we're at that point. Would anyone like to address that question?
Dana, you go.
Yeah, I have lots of thoughts on that. It's a tough issue, especially when it comes to predators that have been systematically eradicated from wilderness areas. And we have opposed reintroduction into wilderness in a lot of instances because it's a complicated issue. I know in some circumstances, especially where an animal is listed under the ESA, if it's reintroduced, it gets different protections than it would if it walked there on its own paws. An example of that might be like grizzly bears coming back to the Selway Bitterroot Wilderness. So if they get there on their own, they're in better shape than if we drop them there, and they might be deemed an experimental population. Another issue with reintroductions is it often is accompanied by a lot of collaring and electronic tracking and helicopter use. And as we've seen in Idaho, particularly with wolves, the data that's obtained from those collars is often used to target the animals for things like aerial gunning. And we have a particularly egregious example in Idaho where they will sometimes use what is called a Judas wolf, where they will slap collars on the wolves, track them back to their den sites. They will kill all of the wolves in that pack except for one wolf, leave the poor wolf with the collar on to go out and find a new pack, and it keeps getting retargeted for extermination efforts. So, the other issue, just sort of speaking a little bit more broadly too, is we are going to be seeing a lot of changes with climate change, both with animal populations, with vegetative populations, and we're going to see a lot more pressure, I think, to intervene in wilderness to maintain conditions. And I think a lot of times the agencies are conflating natural conditions with desired conditions and trying to hold static baselines in an area that is wanting to change. And so this is where we really need people standing up for the idea of wilderness in these areas and allowing these areas to respond to the input in a way that it will, whatever shakes out in those areas is what shakes out, and that sometimes there are discrete problems that are a bit more complicated to take on. There might be something where we could take one discrete action to sort of correct something that we've done. Like if we've got a patch of spotted knapweed or something like that popping up in wilderness, maybe we can get rid of that pretty quickly. And we don't have to have a lot of repeat interventions in the area to deal with that. But oftentimes that's not the case. So this is a conversation I think that we need to be having more of, and unifying our voices on this is to stand up for wilderness.
Thank you for that thought there. It really is quite a complex issue, and something, like you said, discussions are going to need to continue to happen around this. I do want to note a couple things. There has been some discussion in the chat about whether we might have a way of having a list of areas where citizens are needed to assist in wilderness areas. For example, going out to the Fred Burr Lake and having a list of certified crosscut sawyers who could be called in to do that work, or in other situations like that. So if there's interest in that, please let us know. That is something that Great Old Broads could certainly help to coordinate or keep a list of, or we could be working with Wilderness Watch and others to look at some kind of clearinghouse of places and tasks that are needed where we can provide boots on the ground information for wilderness protection, and some of that may eventually end up in litigation. So I wanted to note that. And there was one other question that has been answered about whether, I think it's important, whether you can become an interested public in the Forest Service. And Talasi has answered, the interested public concept is unique to the BLM, but you can try to sign up to get notified of projects of interest with the Forest Service by asking to be put on their scoping list. So thank you, Talasi, for that. So I think we're closing in on 1:30 here, and I really appreciate the detailed case studies and examples that all of our guest presenters have provided today, and the knowledge that they bring to the table. I would ask all of you to consider joining and supporting their organizations as well as Great Old Broads. We're all in this together, and we appreciate and often work together on these very issues, and hope to do more of that into the future with your help. So thanks to everyone, and we will see you later. And if you have questions, please continue to write to broads@greatoldbroads.org.
Will you send the recording around everybody that is on the list?
Yes, everyone who registered will be receiving the recording by email.
Thank you.
Thank you very much.